Hello everyone and welcome to today's Mondac webinar in association with Ghafari Partners, who will discuss recent trends in international arbitration law, practice and procedure across the MENA region. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. Amir Ghafari is an experienced international arbitration partner. He has acted as counsel in more than 100 international commercial and construction arbitrations administered under the rules of all the major arbitral institutions, as well as in ad hoc proceedings. In addition to his arbitration work, Amir regularly appears as an advocate before the Dubai International Financial Centre Courts of First Instance and Appeal. He represents clients across a number of sectors and has developed particular experience in relation to large, complex and high-value infrastructure, energy and construction disputes. Julia Didon-Kerr is a specialist arbitration practitioner and has represented clients in commercial proceedings under the rules of all the major arbitral institutions. She has also represented clients in high-value investor-state proceedings under the ICSID rules and UNCITRAL rules, including on behalf of investors against the Republic of Kazakhstan and the Republic of Lithuania, and advised states in relation to proceedings brought against them. Julian Haslam-Jones has 20 years experience in claims management, contract risk management, commercial management, cost management, procurement, negotiation and amicable settlement, mediation, arbitration, prolongation and delay costs, escalation, project management, project controls, project monitoring and program management. Julian has an LLM in construction law and arbitration, an LLB honours in law, and is a fellow of the Chartered Institute of Arbitrators. Now, before I hand over to our panel to begin today's webinar, a housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. The panel will endeavour to answer as many questions as possible during our Q&A session at the end. It's now my pleasure to hand you over to Amir, Julia and Julian to begin. Thank you.
Dan, thank you for the kind introduction, and hello everyone. It's our pleasure to be hosting this webinar on hot topics as we see them in international arbitration practice and procedure in and through the MENA region. We have 4 subtopics that we would like to take you through during the course of the next hour. And as Dan says, we encourage your questions along the way through the chat function in order to make this an interactive session. I'll start by just outlining the 4 subtopics and then we will take those in turn. Topic 1 concerns the impact of inflation on businesses and their disputes, and in particular we'll look at price escalation issues through the region. Topic 2 will look at parallel proceedings and alternative procedures to resolve disputes, and in the course of doing that, to minimize risk and reduce costs, which of course all of our clients want us to do for them. Topic 3 concerns the risks and pitfalls of enforcing arbitral awards in the MENA region, assuming one gets to the end of an arbitration and there's an award to enforce. And finally, we'll touch upon some geopolitical considerations that we all see in our day-to-day work for our clients. So that's broadly the roadmap for today. With that, I'll hand over to Julian to take topic 1. Julian, over to you.
Thanks, Amir. Thanks, Dan, for the introduction, and hello, everyone. If I could just ask for the next slide to be put up, and I'll go through looking at the inflation issue that we're seeing across the region. So I've sort of broke it down into a quick look ahead. It's going to center very much around the industry that I'm in, related to construction. So I'm going to talk about the elements of work that are subject to escalation. Going to talk through escalation clauses, so how this issue has traditionally been dealt with, some of the disputes that we're seeing, and what to do in the event that there's no escalation clause. And a topic that we're dealing with a lot is that in the event there's no escalation clause, how do you actually demonstrate and evidence such costs? Can I have the next slide, please? So I just wanted to bring up just an idea of where we are with inflation. This is the consumer price inflation index. I've got a spread of countries on here: China, UAE, Japan, US, and Germany. As you can see, there's been a trend from sort of, just the start of 2020 and up through to sort of the past 2022, where inflation has increased dramatically. I know on the chart it shows it dropping off now, but I think, what I'm seeing in the market is definitely not that case. And also just reading and talking to people from different industries, I don't think inflation is going away. I think there's still a lot to be done by the central banks to manage it. I think the important thing to take away from this for everyone is this is a global issue, and therefore, if you look back in history, the last time that we had to deal with this is in 1982. So getting expertise on this is challenging, and you need to look back to it quite a way back to look at the last time this was a problem. And everything's moved on, technology's moved on, the global market's moved on, and these are now some larger challenges dealing with this issue. Can I have the next slide, please? So I've just put up here how inflation links to escalation. The key thing about this is really, the escalation clause is there to try and deal with inflation. So adjust the costs to match where you are in the market at the moment and mitigate the impact of inflation. I'll talk to you about how the escalation clauses work and some of the challenges, but I think in summary, when you have inflation in the market, especially in construction contracts, it's used, the traditional way has been to use escalation clauses to mitigate the impacts of this. Some are adjusted based on indices or formulas, and I'll talk a bit about that today as well. And when we're going through this topic, I think it's important that people realize, if you are having a mechanism in your contract where you are trying to deal with the risk of inflation through an escalation clause, it goes up and down. So when you're looking at things, some things might go down, some things might go up, and it's always important to consider that. Could I have the next slide, please? So elements of the work that are subject to escalation, it varies depending on the agreement and industry. I think that's important. So we could be talking about an offshore platform that will be affected very differently to a hotel onshore. So it depends where the industry. It also depends on the agreement as well, which it could be a lump sum, it could be cost reimbursable. I think it's important that it clearly identifies and defines the elements that are subject to escalation. You can agree on terms and conditions and the calculation methods and provide clarity and transparency and adjustments over time. Can I have the next slide, please? So I've just put up some key factors here that you need to consider. Pricing and rates. Obviously, labour costs, we're seeing that being heavily affected by inflation over the last couple of years. Raw materials and inputs are very challenging, and they can vary dramatically. If you take something like steel, the different parts of a project may dramatically vary. So you might have one part of the plant that has been constructed that maybe doesn't have such a large impact from inflation, and then you can have another which is impacting 100-200%. So I think raw materials and inputs is a real challenge. Labor is a bit more consistent, but again, you need to be careful where you are in the world or where the labor is coming from. Energy costs, transportation and logistics, and tax and duties as well. Can I have the next slide, please? Okay, so I'm not sure in the audience whether people are familiar with escalation clauses, but I've just put up a couple of definitions here. Basically, it's a provision in the contract that calls for adjustment in fees, wages, or other payments to account for fluctuations in the cost of raw materials and labour. it shares, I've said here, it shifts the burden of increasing materials and labour costs from the contractor to the client, but equally anything that goes down shifts back to the contractor as well. So it's quite a balanced approach, and if drafted well and administrated well, it does work. Could I have the next slide, please? I just put up some key points to consider about escalation clauses in contracts. Purpose, trigger events are very important. They must be defined, and you need to be careful when these mechanisms kick in. Adjustments, how the adjustment is being done, notice and calculation. You do need a dispute resolution around it. I do have on my desk at the moment a dispute about an escalation clause. It's down to how it was drafted, if I'm honest with you, but in the event there is a dispute, I think you need to have a mechanism there. Legal implications as well. You can speak to people like Amir and Julia about the importance of this, what you're signing up to, and these kind of things. It's important that you understand how the mechanism works. Can I have the next slide, please? I put up this one because this is a common issue. So I think you really need to consider, if the project's delayed, how does this work? You know, what happens if there's an extension of time or the project's delayed? Who takes the risk on the escalation? Is there a mechanism that works properly? Does it deal with in the event that the project's delayed or there's an extension of time? And again, I think that should be clearly set out in the mechanism. There are standard contracts around the world that deal with this. So if in the event that you don't have, you know, you're drafting a bespoke contract, you can utilize those as well. Can I have the next slide, please? And again, I've put up here, you know, what happens with the escalation clause when there's an extension of time. You know, is it time-based adjustment, cost-based adjustment, renegotiation, or adjustment provision? You need notice in the documentation and in dispute resolution as well. So this is really important, because if the project's delayed and the parties agree, okay, the contract is entitled to an extension of time, it can get complicated about how that's calculated. So again, I think it's very important that the escalation clause covers this. A traditional position would be the costs are recovered, but I've seen different mechanisms applied. Can we have the next slide, please? Another one that you want to consider is when the work is varied. So if the client issues a variation, how is escalation done? This should be addressed, you know, and in the variation mechanism, it should cover if the escalation issue comes up. I think communication, documentation, and transparency are critical on this between the parties, and adjustments should align with the changing work requirements. Can I have the next slide, please? I've just set out here how escalation provisions may be handled in such cases. There needs to be a clear definition of the work of the variation, how escalation is applied. So, there normally is separate escalation rates, the change order or amendment process, and cost allocation and pro-rotation, and communication and documentation. I think all these points are important when you're looking at this, when it relates to varied work. Can I have the next slide, please? So what I've been talking about to you now is when you have, up to now, is when you have an escalation clause. But when you don't have one, this can be where the challenge is. Now, I won't get into the legalities of this. I'll let Amir and Julia cover that. But when there is no escalation clause, but the parties agree that there's entitlement to deal with the issue, there's various ways that you can deal with this. You can look at it from a negotiation point of view, so you could do it as an amendment or addendum. You could use market-based indices. You definitely need to probably consult legal and financial professionals to get some idea about different mechanisms and legally where you stand. And the other really important thing is that there's documentation to support what the cost impact is on the works. Can I have the next slide, please? And I've put this in as well because this is a common issue that I see, and it's really important this is addressed from the outset of the project. Some people, when they're putting their pricing together at the start of the project, aren't considering this. You can, of course, use published indices, but in my experience, that's incredibly challenging to find one indices that suits all the type of work that you might be doing, especially if it's on an international project. If I take projects here, there's many elements of the project that come from around the world. Trying to find one indices that will suit all is very challenging. I think what you'll probably end up doing is demonstrating actual costs. So it's very important that you have the right records from the start. So what you should be doing is looking at, when you're putting your tender together, making sure that you're accumulating market data on what that tender is based on, so you can demonstrate your base case. And then you need to record what your actual costs were. And then you should be able to show, well, this is what I originally allowed, and this is what's happening in the market. And if you have all the documentation, then you should be able to prepare a detailed cost analysis. Can I have the next slide, please? Okay, so that's pretty much everything covered. I hope that sort of gives you an overview of some of the typical issues we see. Amir and Julia, I don't know if you want to add anything to what I've already said.
Thanks, Julian. Yes, it might be worth just picking up the distinction between scenarios where you have an escalation provision in the contract and those where you don't. The first one, ultimately, if there's a dispute as to who picks up the additional cost, is a matter of contractual construction. What does that provision specifically say, and which party, by reference to that provision, is responsible for the cost overrun, if I can put it that way? The more interesting scenario is the one that we've seen a number of times over the course of the last 18 months, where there isn't an escalation provision in the contract, or the escalation provision simply doesn't cover the mischief, so the additional cost. In those scenarios, Julian's quite rightly outlined the various approaches. One, and it's a point of obviousness, is to sit down as parties and seek to negotiate a fair resolution. The second one, which is a situation that certainly we have seen a number of times of late, is where one of the parties simply says, no, there is no provision for additional payment. The increased cost of, say, the raw material in the market is at your risk. You can't come back to us for that cost. Clients that have come to us have initially, and I think quite rightly, pointed out maybe the unfairness or unreasonableness of that type of approach. And so what we do as legal, and we work hand in fist with the likes of Julian, is we look at first at the contract to see if there is any other provision in the contract that may back up the point. So it won't be an obvious escalation provision, but there may be something else in the contract. For example, it sets out a provision in relation to the application of good faith and the performance of the contract, and whether we can use that to assist our client to somehow mitigate the risk of the additional cost that it needs to meet due to inflationary issues. Where it gets a little bit more interesting, at least for lawyers, is where there isn't another provision in the contract. And in those circumstances, we need to look to the applicable law. Are there principles as a matter of the applicable law, principles of fairness that we can use to write to the other side and say, this particular issue needs to be dealt with in a fair-handed manner? Ultimately, it comes down to an attribution of culpability. And again, this is another step in terms of what one can do. Sometimes it's not obvious that the increase in price is one that should be borne by the party that doesn't have the benefit of an escalation provision. What do I mean by that? Let me give you an example. We've recently worked on a matter where the price of a particular commodity, raw material, has spiked over the course of the project. And when we looked at the papers, we dug back about 2 years and found various requests by our client asking to procure in advance stocks of that material. The response from the other side was consistently, no, we don't want you to do that. That response led to our client not doing that and having to go into the market 18 months later to buy those raw materials, at which point the price of the raw materials had gone up very significantly due to inflation. The argument we then ran successfully was that it's not our client's fault. Our client looked to procure the materials in advance. It was not allowed to do so, and therefore the risk shifts. It was a novel argument, and ultimately it wasn't tested before any tribunal, but the fact that we put that argument forward ultimately resulted in the settlement of that particular issue. So I think it's important when you have these types of issues arising on particularly large projects to look at the project in the round, to go back into the history of the project and work out what arguments can be run in terms of who picks up the additional cost. That's my only observation. It's a slightly longer one. Julia, do you have anything to add on that particular point?
No, I think all the points that you covered, Amir, are valid. And I think that the key takeaway for me is, from my aspect, from my side, is that when you're dealing with these issues with escalation, one, be very careful about the mechanism that you're agreeing, because as you say, that's the first point of call. And you need to really look at how that will work through costing the work and making sure that you are mitigating the risk. The second point is that in the event that you aren't having a mechanism in the contract, or you are aware that you're entering into a contract where this isn't defined, I think dealing with it at tender stage, which isn't a lot of work, but just documenting what your actual costs are based on, does help as well in the event that you do get into a situation where you may need to demonstrate it. That's a key aspect, because that will show your base, and anything from there you can then build with the records that you've got. So yes.
We have a question, perhaps we'll take it now, from Mr. Abdullah, who asks, this is a question directed at you, Julian, is there any standard clause of escalation that you may suggest so the parties can use it in their bespoke contracts? In essence, are there standard clause escalation provisions that one can deploy?
Yeah, there are. I think depending on the project, there's different types of standards. I mean, FIDIC has it, for example, but you've got other clauses, other standard contracts that are suited to different industries. And it is, a good practice to start with a standard clause. The issue will always come is there will always be some amendment, and the other key part of this is the indices, or the pricing mechanism. Standard clause will set out the mechanisms of what happens between the parties, but the actual pricing mechanism won't be defined, and you need to research that heavily to make sure that it's appropriate for your project, where that is in the world, and it covers all the different elements. There is one other thing that I would say on this, and I do think pricing escalation clauses is very challenging, is that I had this recently where, as an alternative, a client came to me and there was a large part of the works that he was extremely worried about, and it was actually the operator, so it was the end user, and he was saying to me, look, I'm just very worried about how we're going to deal with this. And I did say, well, an alternative to an escalation clause is just to make that part of the work a different price model at cost plus or whatever, so you're getting the same thing. As long as it's clearly set out, you're paying the cost of the works plus whatever relevant markup and things. So there are alternatives. And again, when you're sitting with a client, I think the key is to work out something that isn't going to harm either party. The whole point in it is that it deals with escalation and just covers whatever that impact is. It might be minus, it might be plus, it might end up being neutral, but the parties then are able to deal with the impact of inflation on the project.
Great. Why don't we move on then to the next topic and take the questions that are coming in at the end. So we're moving on now to parallel proceedings and alternative procedures to save costs and to minimize risk. Thank you. So what I'd like to do is to take this in relatively short order. I'm mindful of the time. When we talk about parallel proceedings, I just want to start off by making the distinction between two concepts. What I don't want to discuss here are parallel proceedings that are brought in breach of the party's dispute resolution mechanism. One obvious example is where the parties have agreed to arbitrate their dispute, and one of the parties rushes off to the state courts and issues a claim before that court in breach of the arbitration agreement. That's not what we're wanting to discuss here. That, as I see it, and there are often good strategic reasons to do that. It might be that the party doing that is looking for some form of injunctive relief, some form of other urgent measure that doesn't lend itself well to starting an arbitration, although, as you'll all know, most arbitration rules have provision for emergency or interim or early provisions. That rush to the state courts in breach of an arbitration agreement is what I set out in this slide and refer to as a form of dilatory tactic. It's seeking to take the reins and push the process in a direction that was not intended by the parties under their contract. And very often it will lead to the other party seeking some form of anti-suit injunction, either appealing to the same court before which the action has been brought, or to an arbitral tribunal, or indeed sometimes to another court, for example, the court of the seat of the arbitration agreement, to seek an order, in essence declaring that the action brought before the first national court is somehow in breach. What I want to talk about are parallel proceedings that are used commercially as an aid to resolution, and you see that in the third bullet. And this is really the commercial approach that the clients increasingly want from their advisors, whether it's Julian and his team or lawyers, or indeed other professional advisors. And really what clients are asking for here, but I think it's an area that needs more development in the MENA region. The client has an arbitration agreement. The client is facing, let's say, a 2-year ICC or LCI arbitration because it's a complex mega project, and that's how long these types of disputes tend to run. At the same time, and this is what we increasingly say to our clients, there is nothing wrong with a parallel proceeding. So not a formal parallel proceeding in the sense that it's unilateral, it's brought before another court, but rather the parties agreeing at the same time as they're seeking to either arbitrate or start or consider arbitration, a form of mediation or alternative dispute resolution. I want to deal with those in turn briefly. If we can go to the next slide, please. Mediation and expert determination. You'll all no doubt be very familiar with the concepts. Starting with expert determination, there is in the Middle East still a sense that expert determination rings of an expert appointed by the court to determine the issue and seek to impose a binding decision. That's not what I'm talking about here. Here I'm talking about the parties agreeing to an expert on a without prejudice basis to look at the issues as between them and seek to at least give a view. Now that view can be binding, but often it's not. It's more intended as an indication that if this dispute were to go forward to arbitration, the likely outcome will be X or Y. That type of approach, and it's the same approach that's deployed in mediation, is very helpful, because what it indicates and signals to the parties is this is probably where the merits of the case lie, at least as far as that particular expert determiner or the mediator sees. In my practice, I sit as an arbitrator, but I also sit as a mediator. And I find that when you can get the parties together after a very short process, no more than a couple of months, the exchange of mediation statements, in a room for a couple of days to hash out the issues on a without prejudice basis, so no one is foregoing its right to go to arbitration, that can often lead to a far quicker resolution of the dispute. And that's the approach that we increasingly try to take for our clients. And it's the approach that we increasingly see our clients come to us for. They do not want to be embroiled in a lengthy 2 or 3 year arbitration. How to structure the process, and that's the beauty of the process lies in the fact that the parties can structure the process as they wish. They can decide a form of bespoke mediation or expert determination, one that gives them the comfort to fully engage, and the mediator or the person determining the dispute to push it along. Clearly, this achieves 2 things. One, it reduces costs if the process can be managed well and if the process is successful. Even if the process is not successful, in my experience, it still reduces costs, because just that process focuses the mind for the arbitration. And what you often see is a lot of the issues fall away, because through the mediation process, the parties have realized that the particular point or points they're running may not be strong. And so they drop them when it goes to arbitration. The other benefit of this type of parallel proceeding is that it avoids certain risk. One risk is obviously the risk of cost. 2 is the risk of adverse decisions on points, because you've kicked the tires on those points during the course of the mediation. And the third one, from an internal business perspective, is aligning the business at all levels, including the C-suite, to the issues, because they've almost run a mini process in parallel up front. And so everyone within the organization is alive to what may come next. On at least a couple of occasions in the last 2 or 3 years, I've seen that, I would call it an education of the issues in terms of the dispute that's imminent, has gone up to the top and has come back down with a settlement proposal. If we go to the next slide, I think I'm going to pass over to Julia in a moment. But before I do, Julian or Julia, do you have anything you want to cover on those particular points that I've raised?
I think the efficiency points that you raised, Amir, is key. So even if that parallel proceeding isn't successful, the idea that it can better define the issues, which often is what we say is a waste of time and cost in an arbitration, where the issues change as the arbitration goes, because they haven't been thought about properly before or well defined by the parties. So that's definitely an added value of the process.
Thank you. So why don't we move on now to topic 3, and I think that's over to you, Julia.
Yes, that's right. Right, so today I'll talk about the risks and pitfalls of enforcing arbitral awards in the MENA region. Although we're looking at the negatives, therefore, of enforcement in the region, I just wanted to start with this positive message on the first slide, which is a quote by the former Minister of the Economy of the UAE in 2010, who said, "Arbitration is one of the key instruments to resolve disputes amicably and thus enhance investor confidence in the economy's fundamentals to support businesses." Now, this might be an obvious statement to all of us attending today, but it highlights the UAE's and other countries in the MENA region's desire to create a reliable arbitration system in order to attract investment into their countries and live up to their reputation as new and successful business centers on the world stage. And that's very important to keep in mind and understand when we're considering arbitration issues such as this one in the MENA region. And this brings me on to my next slide, please. So we know that a well-functioning arbitration system is fundamental to the creation of investor confidence and the attraction of investment into a country or region. A crucial factor of a successful arbitration system is the existence of an efficient enforcement regime for arbitral awards. Now, what's enforcement? Well, very simply, unless the award is complied with voluntarily by the losing party, the winning party will need to take steps towards enforcing its award in order to recover the funds that were awarded to it. As indicated in the quote that we saw earlier, individual countries in the MENA regions have been taking steps to make themselves more attractive as arbitral venues, including by introducing new arbitration laws, creating new arbitration centers, and also with their local courts making increasingly pro-arbitration decisions. But despite these positive developments, and also many instances of awards being enforced in the region, there are some issues that remain in relation to the enforcement of arbitral awards in the MENA region. And today I want to look briefly at the concept of enforcement, how the system works, before turning to some of those difficulties that can be met when enforcing in the MENA region, and then concluding with some best practice tips for parties in relation to the enforcement of their award and how to best deal with those issues. A brief note at the outset is that the MENA region obviously is a vast region, and the applicable laws and attitudes of the different jurisdictions within that region will vary. So for the purpose of this presentation and the limited time we have, I'll only touch upon some of the notable examples that will illustrate the issues that we're talking about. But if you have any questions in relation to a specific jurisdiction, it's important to take the specific legal advice in relation to that. And please feel free to contact us separately if you need to do that. A quick other note is that some jurisdictions in the MENA region make a distinction in their local arbitration laws between domestic awards and foreign arbitral awards. And today we'll only be talking about the latter of those two. If we can turn to the next slide, please. So enforcement in a nutshell, well, in the best case scenario, as a winning party in an arbitration, you'll want to have an arbitration that was seated in and has enforceable assets located in a state which has signed up to the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards of 1958, the New York Convention, which is a mutual enforcement treaty for arbitral awards that's signed by over 160 states at the moment around the world. Why do we want this? Well, that's because the signatory states to the convention agreed to recognize arbitration awards from other signatory states in their jurisdiction as binding, as if they were local judgments, so without the need to substantially review the case again. You'll see the list on the slide. Most countries in the MENA region are signatories to the New York Convention. But being a signatory is not the end of the matter. So under the convention, there are limited grounds. For the lawyers amongst you, you'll know Article 5 of the convention, on which a local court might rely in order to stop the enforcement of an award. And out of these grounds, the most commonly used is what we call the public policy exception under Article 5.2b of the Convention, which allows non-enforcement where the recognition or enforcement of the award would be contrary to the public policy of the enforcing state. And that's something that will vary in its application between the jurisdictions, but we'll look at this ground in more detail because it's particularly relevant to the question of enforcement in the MENA region. Next slide, please. So public policy grounds under the New York Convention as applied in the MENA regions. Well, there are state courts in the MENA region that refuse recognition and enforcement by relying on a wide interpretation of the concept of public policy. By wide interpretation, what we mean here is a refusal to enforce an award on grounds that go beyond the strictly defined public policy concerns to cover things like cultural or religious factors in the particular country. There's a notable example in Saudi Arabia, because Saudi arbitration law has an explicit mention of Islamic public policy as a ground for refusing to recognize and enforce arbitral awards. So, for example, an award of interest, which would go against the principles of Sharia law, would constitute a ground for the local courts in Saudi to refuse enforcement. We have other examples in the region, in Qatar and the UAE, for example, where the courts have invoked public policy grounds in a very technical manner to refuse to enforce awards. So examples that we've seen in the past for refusing to enforce an award include, in Qatar, that the arbitration agreement did not explicitly state that an award would be final and binding. Again, in Qatar, although this position was reversed later on, a court held that a foreign award which had not been rendered in the name of His Royal Highness the Emir of Qatar violated public policy and therefore was unenforceable. And more recently in the UAE, we're looking at April 2022, Dubai's highest court rejected the enforcement of a foreign arbitral award on the grounds that the arbitrator had not signed the entire award, but only the last page. The courts thought that the non-compliance with the execution requirement under local law, which requires each page to be signed, was a matter of public policy, and that therefore the award could not be enforced as a result. Still in the Dubai courts, now we're looking at late 2022, the same court refused to enforce a foreign arbitral award against a party who had assets in the UAE, but was not actually domiciled in the UAE. Here, the courts held that under the applicable procedural rules, it did not have jurisdiction to look at the enforcement of the awards, and that matters of jurisdiction were matters of public policy, and therefore a ground to refuse enforcement. Of course, we'll have to see how this goes, but if the judgment is upheld, this could substantially complicate the enforcement of foreign arbitral awards in the UAE for parties trying to claim against an award debtor who is not domiciled in the UAE. But the common point to note about all of these cases we've just discussed is that there is a fundamental lack of definition of the concept of public policy, meaning that the concept remains open to interpretation by individual jurisdictions, but also by individual courts and judges within a same jurisdiction. What this does is create uncertainty for the users of international arbitration looking to enforce their awards in certain jurisdictions, including the ones in the MENA region that we've just discussed. We could move on to the next slide, please. Just very briefly, there are other potential obstacles other than the public policy ground for the enforcement of arbitral awards in the MENA region. This would include where countries haven't signed up to the New York Convention. So we've got Libya as an example here, who hasn't ratified that convention, meaning that the enforcement of awards will be significantly more complicated and lengthy in that jurisdiction. There might be countries who have signed up to the convention with some limitations or reservations. So for instance, Iraq ratified the convention specifying that it would only apply to awards issued after 2021. So it's a retroactivity reservation there. And any award before that will not be caught. There might be a requirement to ratify the award first through the local courts, so the executor requirement in Oman and in other GCC countries, for example, which will add a step and some time to the process of enforcement. And finally, other factors may include, quite simply, the lack of familiarity of the local judiciary with the arbitration process or the application of the New York Convention in some jurisdictions, although this obviously improves with time and experience. And political instability can also impact the enforcement of awards, as can changes in government policies, local regulations, etc. On the next slide, I offer a brief conclusion on this topic. So obviously, we understand that enforcement is key to a successful and final arbitration procedure. Whilst the MENA region is becoming a more friendly place in which to conduct an arbitration, it remains the case that in some jurisdictions enforcement is still difficult, and in other jurisdictions it is also untested. So it's still a question in development. The issue of enforcement, as everything else, should be considered very carefully by the parties, even before the execution of a commercial agreement. So to make sure that all formalities are complied with, for example, and avoid having an agreement considered invalid by a court at enforcement stage. During the proceedings, attention must also be paid, particularly for parties who will later on seek to enforce an award in the MENA region to comply with certain formalities. For instance, as we've seen, it's preferable for an arbitral tribunal to sign the entirety of the award, both the operative part and the signature page. And then there are a number of key points to consider at the outset of any enforcement action before a party deploys any substantial resources to enforce an award. And that includes considering, obviously, where the assets are located, considering whether the country where the assets are located is a signatory to the New York Convention, and if so, in what way it's signed up to it, so if there are any reservations. Considering the local law of the jurisdiction where the assets are located, to see whether there are any specific public policy grounds that exist that might limit the possibility of enforcing the award. And also considering the general attitude of the jurisdiction and its local courts as regards arbitration. We'll need to consider what we touched upon earlier, the executor, whether there is that step or not to be met. And finally, consider whether there are any other types of orders, for instance, under local law that might assist with the enforcement of the award. So here we're talking about things like freezing orders on assets, for example, which won't be available in every jurisdiction. But the key is to seek advice early on before drafting a commercial agreement. And because of the difference of between the jurisdictions within the same MENA region, also seek country-specific advice in the jurisdiction where you're seeking to enforce an award. And that will obviously minimize the risk of an enforcement procedure failing entirely or being unduly long and costly as a result.
Thank you, Julia. So just looking at the time, we have 13 minutes available to us. Why don't we move on to item 4, geopolitical considerations. And I'm going to hand it back to Julian for that. And then once we've covered that, I can see there are some questions coming in, so we can deal with those. One in particular on the Riyadh Convention, which I think is an interesting topic to cover. So Julian, over to you.
Thanks, Amir. What I'll do, can I move on to the next slide? So I've set out a format here. Due to time, I'm going to go through it reasonably quickly so we have time for questions. So if I can get onto the next slide, if that's possible. So for geopolitical considerations, this is a very important part of the MENA region, and it's a dynamic region, and you've got unique dynamics in this region, and they do play a vital role in shaping the economic landscape. So if I can go on to the next slide, here's just, I've put up some key geopolitical factors: energy prices and resource dependencies, fundamental, global economic interactions, trade relationships, regional power dynamics, currency exchange rates, and political instability and conflict. I think these are all important factors when you're looking at key geopolitical factors across the region. Can we move on to the next slide, please? So energy prices and resource dependence. I think I'm not going to go through all the points here. I just simply don't have time. But I do think still across the region, depending on the energy price, is still linked with investment in the region. This does have an impact on inflation and other factors as well. But the energy prices still heavily influence the region, and you can see that in the current what's happening in the current environment, where energy prices peaked, and there's suddenly a lot more investment in the region and a lot more things happening. And then you can see OPEC as well having an influence on trying to maintain certain prices to help with the investment across the region. Now move on to the next slide. Global economic interactions. I think this is important, and it's an important part of the geopolitical factors here. Economic disruption in one region can transmit across the global supply chain, and I guess that's the issue now, as we've seen with different crises that have happened over the last couple of decades. Globally, we're so linked by trade now that you can have heavy impacts across, just because it's not within your region. If, for example, there's an impact in Asia, it will definitely impact this region from a business perspective. Can I move on to the next slide, please? Trade relationships and economic policies. I think this is important. I think we're all seeing what's happening in Ukraine at the moment, and that does affect trade relationships, and that is having a big influence across the region in different industries. So I think that is very important, and it also drives economic policies as well. Can I move on to the next slide, please? Regional power dynamics, I think, are important. I think we're all looking at the Saudi Arabia and what's happening at the moment. I'm pretty sure that the plans Saudi Arabia are putting in at the moment will affect all regions. For example, I'm starting to hear in the UAE that there's a brain drain, so a lot of talent is moving into Saudi because there's a huge amount of work there, and that will affect, you know, the workforce here, as an example. Can I move on to the next slide, please? Currency exchange rates. This is important. A lot of the currencies across the Middle East are pegged against certain currencies, so that does make a difference. But currency exchange rates can be a factor that you need to really consider. There are mechanisms in contracts to deal with this, especially if it's volatile, and it can make a big difference. You can make a big gain to your works, or it can make a big loss as well. So it's always important, I think, to consider when you're looking at the currency that you're being paid in, how that relates to some of the currencies that you're incurring in costs and these kind of things. Can I have the next slide, please? Political instability and conflict. I think these are factors that are relevant in the region, and you need to be aware of them. And obviously this can have an impact to the economies across the region. Some economies are very stable, and others are going through a difficult time, and I think it's just very important that when you're looking at whatever you're doing, that you take these factors into consideration. They can also impact logistics as well, and I think we've seen that in different ways with various events that have happened around the region. So I think these are live risks that you just need to be aware of, and making sure that you have the relevant provisions in your contract to deal with it correctly. And then I'll just conclude quickly, and I'm sure these slides will be shared with everyone as well. So I think, you know, there is geopolitical considerations, and MENA is a very important factor in this region. And I think that, you know, we just need to look at what's happened in the last 4 or 5 years, you know, with COVID, with what's happened in Ukraine, how that's impacted the region, and some things positively, some things negatively. But I think all the examples I gave you are very important. And when you're signing up for any contract, whatever business it is, you need to look at these and make sure you're covered correctly and that you can deal with them in the appropriate way. That's a whirlwind tour through it, Amir. So I hopefully I've left some time to get to the questions.
Thank you, Julian. So why don't we look at some of the questions that have come in. There's a question about the Riyadh Convention here, and it poses as follows. Please advise in relation to the enforcement of arbitral awards under the Riyadh Convention, considering that one of the parties to the arbitration agreement is not a signatory to the New York Convention. However, they are a member to the Arab Union and ratify the so-called Riyadh Convention. So this, I think, here is a reference to the Riyadh Convention 1983. There are 18 states that are signatory to that particular convention. Its premise is for judicial cooperation between the courts of those 18 signatory states. And the idea is that if you have a judgment or an arbitral award in one state that is a signatory to the convention, that should be recognized and enforced in another signatory state. It's if you like, a a mini, by which I mean there are fewer signatory states, version of the New York Convention. It comes with some of the same pitfalls, for example, as Julia covered in relation to ratification. If you take the UAE as an example, the UAE has ratified the Riyadh, has signed the Riyadh Convention without any reservation. And so the Riyadh Convention is in effect treated as part of UAE laws. There's a wrinkle though, because those of us who practice or know of how legal practice is in the UAE will know that there are certain jurisdictions within jurisdictions. And in 2021, in a decision of the DIFC court in a case called Lahela and Lamise, the DIFC court held that the Riyadh Convention is not part of DIFC law. So it's part of the UAE law, but the DIFC has its own jurisdiction. So there are these wrinkles that one needs to be aware of. Other than that, the broader point is that you need to look to the states and to see how they, on what basis they ratified it, with reservation or without. The answer to the question posed, I think, is this: if one of the parties is, or enforcement is in a state where is signatory to the Riyadh Convention, then you can enforce it there. But the important thing is that both parties have to be from states that are signed up to the Riyadh Convention. You can't take an award from, say, a European state and seek to enforce it in a state that is a signatory to the Riyadh Convention under the Riyadh Convention. And if that state hasn't signed up to the New York Convention, then you've got a problem. So it's a case of looking at who signed it, where enforcement is to take place, and what treaties, if any, are in place to assist you. Let's move back then. I think there was another question posed. Yes, from Mr. Abdullah, and this concerns good faith unjust enrichment. So how do you see the chance of the contractor, if he claims, and I think this is in relation to inflationary issues, on the basis of good faith and or unjust enrichment, if the contract expressly states that price volatility is under the contractor's own risk? In other words, no provision provided for escalation. I think we covered this in part earlier. The tricky issue there is that if the contract doesn't provide for price escalation, then you can't look to the contract. I mentioned earlier that you can look to applicable law. Unjust enrichment, I think, will be very difficult, because it doesn't necessarily follow that because the contractor has to cover the additional cost, that the other party has been unjustly enriched. It just so happens that the price of the particular raw material or commodity has gone up, and under the contract, it's the contractor that has to pay for it. So I think unjust enrichment will be very difficult to run. Good faith might be a better avenue, depending on what the applicable law says in relation to good faith. And I think this goes back to one of the points I made earlier, which is you need to look back to the project itself to see if both parties have sought to perform the contract in good faith, where the one party possibly hasn't taken the right or fair steps, and on that basis seek to at least dilute the impact of the cost overrun. As general principles, though, I think good faith and unjust enrichment, absent facts that assist you, are difficult legal arguments to run on this particular point, because I think most tribunals and courts will look to the parties' contract, and particularly if the parties are savvy operators, that's what the parties agree to. And tribunals in particular are reluctant to step outside the four corners of a contract. Those are, at least for the time being, the only questions that have come in, which helpfully takes us on the dot to 2 o'clock. And unless Julian or Julia, you want to add anything else, I'm minded to pass back to Dan for a wrap up.
Nothing from me, Amir. I think you covered it well.
Great. Dan, back over to you.
Brilliant. Thank you very much. And to end today's webinar, I would just like to say thank you very much to our panel, to Amir, Julia and Julian for an incredibly informative webinar. We really appreciate your time today, and we do hope that we see you again. Thank you also to our audience for being with us today. Once again, we appreciate your time being with us today. So once again, thank you, Amir, Julian, Julia, for all of your insights today. We do hope that we can see you again. But for now, I wish you all a good day. Goodbye.
Thank you.